I am going to try and tell this story succinctly. So it was 1987, and my father got caught in possession of child pornography. That investigation led to the Nassau County Police Department going to the homes of parents who were sending their kids to our house for after-school informal computer classes that my father ran in the house and I helped him with when I was in high school. Through the course of that investigation, the police managed to walk away with statements from a handful of children who said that they had been sexually abused during the computer classes. Those statements eventually became 450 some odd counts, covering 4 years or so worth of computer classes, 20 some odd students, and depending on how you count it, as many as 5 defendants who were said to have been conducting group mass child molestation during these hour-and-a-half computer classes in our house for a number of years, with absolutely no ability to expect that we could defend ourselves against these charges, and with the weight of my father's possession for child pornography on the case. My father pled guilty. A few months later, I ended up also pleading guilty to crimes which I knew never happened. That was 23 years ago. And then it was in 2001, it was my 13th year in prison. A guy by the name of Andrew Jarecki came along and started making a movie about my oldest brother, David, who is a birthday party clown in New York City. An incredibly famous and pretty darn good birthday party clown. And Andrew Jarecki was going to make a movie about people who spend their lives entertaining children at birthday parties. And then Andrew Jarecki discovered who my brother's brother and father were, and it made a much more interesting story. And that story became Capturing the Friedmans, as most of you know. Gosh, I am keeping it short. I am proud of myself. Look at that. Before Capturing the Friedmans was finished, before it was released, I got out of prison. Had an incredibly difficult time of that transition, considering I was 18 years old when I was arrested. After a year on bail trying to fight the charges, go to prison at 19. 13 years later, I get out of prison. I know nobody. I know nothing. I was under extremely severe parole restrictions, and then Capturing the Friedmans started playing in movie theaters. And everybody started looking at my conviction in a whole different way, even though I had been trying to tell people my side of the story for 15 years pretty much up to that point. The fruits, per se, of Andrew Jarecki's 2 years of talking to people who were involved in my case, either the judge, the defense attorneys, the detectives, the children who were in the computer classes, Debbie Nathan, who was here and might still be here. Hi, Debbie. The material he was able to collect that pointed towards my innocence, Mr. Kuby and I have been able to put into a wonderful, wonderful appeal, which was not easy. It started off with a team of perhaps 10 people, mostly all volunteering their time and efforts to put together the initial motion papers. Those motion papers went to Nassau County Court, where they were summarily laughed at. And over a course of a few years, we had to work our way through Nassau County Court, and then we worked our way to the appeals courts, At that point, Ron Kuby came on and tried to see what he could do with what had been brought up to that point. And in federal court, we had a much different reception from the judges than we did in Nassau County. And I think enough time had passed from the hysteria of the 1980s, and enough cases had been shown to be fictitious that the judges were willing to give our motion papers a fair reading. And I think I could probably let Ron pick it up from that point.
I just got to do a few shout-outs to begin with, because any case like this, as big as it is, has required the work of a lot of people. Debbie Nathan, who is in the audience, has done groundbreaking research on the areas that ultimately have led us to the fairly good point where we are now. Emily Horowitz, who I know as Emily, you all know as Professor Horowitz, donated hundreds or thousands of hours working with the social science material, the legal material, working with the lawyers, putting together a set of papers that, you know, over, 12 years, finally got to convince some people that this was all being taken seriously. And lastly, a St. Francis student who has also been working on the case and is my administrative assistant, Chelsea Sirigotis, who may have had to leave already, but she's worked on this as well. So it's nice to be called such great things by people, but this has very much been a team effort. I just happen to be the most high-profile member of the team, except, of course, for Jesse himself. Now, to talk a little bit about the case, think of this, if you will, and this is a point that I've been making over a period of 12 years. The most sensational allegation that was made against Jesse by a grand jury and the Nassau County District Attorney's Office was this. In this quiet suburban home on a tree-lined block where dozens of computer students and their parents would walk in and walk out without any advance notice or knocking, what happened, according to the prosecution, was on a fairly regular basis, the computer students, sometimes as many as a dozen, would be stripped naked by Jesse and his father, who would also be naked. They were put in frog-like position on the ground. And Jesse and his father, over the course of an hour, would repeatedly sodomize them, that is, forcible anal intercourse with 20 naked boys, over the course of an hour in the home. And the amazing thing about that was not only, like, really? But none of these kids ever complained. None of them had a symptom. None of them had a shred of forensic evidence. And you would imagine with some horrific a story like this, there would be blood and feces and semen and physical... It would be disgusting. But it never happened. And we started with the basic proposition that the reason we know this didn't happen is this could not have happened, right? This could not have happened. Life as we know it on Earth doesn't work this way. Something is profoundly wrong. And sort of starting with that basic premise that this cannot be true, we've spent about 12 years unraveling the process by which we got here. And it has been a very long process indeed. This began in 2000, actually, with Andrew Jarecki's film, starting to make the film. The film finally came out in 2003. Now, Jesse is now out of prison. Then we filed our papers in 2004. It was denied in 2005. We appealed in 2005. It was denied in 2006. We filed in federal court in 2006. Judge rendered two separate decisions dismissing the petition in 2007 and 2008. Then we appealed to the highest federal court we could appeal to, the United States Court of Appeals for the Second Circuit, which took until August of 2010 to render its decision. And when it rendered its decision, it said, among other things, the following: emotions like fear, outrage, anger, and disgust in situations like these are entirely human. The question is what the legal system can do to correct for the excesses to which they lead. The crux of the moral panic dynamic is that the legal system in such cases does not correct for them. It gets swept up in them instead. The record in this case suggests this is precisely the moral panic that swept up Nassau County prosecutors. The court said there is a substantial likelihood that Jesse Friedman is innocent. I'll have to wait on questions just till I sort of finish, and then we'll have a back and forth. And ultimately suggested strongly to the Nassau County District Attorney that she reinvestigate the case. And to my surprise, she did reinvestigate the case. And to my further surprise, even after she lost the Democratic primary for the Attorney General nomination, she continued to investigate the case. And we are expecting the results of that investigation sometime in the next few months, and I am cautiously optimistic that they will formally exonerate Jesse Friedman. And we don't have a lot of time, and I know that you all have a lot of questions. Are we out of time? I'm good? 2 more minutes, and then we'll... Another what? 2 more minutes? Oh, let's do 2 more minutes. Let's just do a simple exercise and talk about wrongful convictions generally. And by wrongful convictions, I mean the person actually didn't do it. Not, his rights were violated, he was arrested because he was black, or this or that, all of which happens constantly in this system. But I'm just talking about plain, flat old, didn't do it, wrong guy, wasn't there. Or in fact, the alleged crime never took place in the first place. Of the people, and I just want to get a sample, given the fact that the legal system is based almost entirely on human perception, human judgment, human evaluation, often under very, very difficult and frightening circumstances, what percentage of people do we think have been wrongfully convicted right now in America's prisons? Just since, by the way, nobody knows. So your guess is as good as anybody else. Because the only way we find out that somebody's been wrongfully convicted is if their conviction is overturned. And as you've gotten a sense, it takes a lot of money and a lot of resources to get a conviction overturned. So nobody really has any idea. But I'd be interested in hearing your guesses. Anybody want to guess what percentage? Give me a percentage. 40%. You think 40% are wrongfully convicted? I'm thinking of Texas and Mississippi throwing in. Right, yeah, of course. We got to throw them in. They're a part of America. 15%. 15%. That's, I think, a more conservative estimate. Any others? You think 75% are wrongfully convicted? Okay. 10. Yeah, really, Jesse. Damn. I love you all so much. I wish I could freeze dry 12 of you and put you on all of my juries. Okay, let's take, anybody think it's less than 10%? 5%. You think it's 5%? Anybody think it's less than 5%? Okay. Okay. I know, but you know better. You know, because you've been there. You've been down for 13 years. Let's take the 5% figure as an extremely conservative estimate of the percentage of wrongfully convicted people. Well, in America, we have 1.6 million people in prison who have been convicted. Now, if 5% of those, which we agree is a conservative estimate, if 5% of those people are innocent, that is 80,000 innocent people, my math is right, in prison every single day. That's a lot of people. That's a lot of innocent lives being destroyed. And this system can do better, and it should do better. Thank you.
In a great many of similar cases to mine, with the daycare cases, other mass hysteria sex abuse cases, there was always this presumption of innocence, that the defendants could sit by, stand by, and sort of face the world with that kind of integrity. And unfortunately, with my father's situation, he was a pedophile. He was caught with child pornography. He had been inappropriate with children at other times in his life. I know, since I was there, that my father wasn't sexually abusing the kids in the computer classes. But my father felt guilty. He basically, he was guilty. He was a pedophile. He was in possession of child pornography. He was charged in federal court with sending and receiving child pornography through the mail. He was going to prison. That was an assurance that my family and our defense counsels knew. And there really was no way around that. The only question was, for how long? And my parents' position collectively was that my father was a walking dead man, and so his situation did not matter whatsoever. My mother disowned him emotionally, basically, and said, to hell with you, go to prison and die. And my father facing no opportunity of hope of not going to prison, and as far as he was concerned, a year in prison or 20 years in prison, that was a death sentence. Our attorneys expressed this possible hope that if I were to go to trial without my father as a co-defendant, that I might have a better chance at my trial. To go to trial with my father as a co-defendant, when the prosecution stands up there with the child pornography magazines, it's over. That's it. The jury doesn't even need to deliberate. Of course, this was a better option, not a good option. And since my father was going to prison on the child pornography charges, the lawyer struck a deal whereby if he pleads guilty in state court, he would get a concurrent sentence in federal court. He could serve his sentence in federal prison instead of a state facility. And it was a good deal for my dad. And he took it. And it probably wasn't the worst advice. It was a possible option given the state of the case at the time. And if things had stayed like that, I most certainly would have gone to trial, and I could very well have had some not terrible outcome from the trial. However, the police looked on these change of events and still had to find a way to assure that their police work was not going to be questioned in front of a jury and in front of the press and in front of witnesses in the courtroom. And they did not want a trial. They wanted to wrap this up and move on. And they went about continuing their investigation and managed to arrest a third defendant, a guy I went to high school with who lived up the block from me. He was arrested. He was charged as my co-defendant. The prosecution offered him a deal that if he testified against me, he would get a sentence of 6 months in the county jail, probation, and a sealed criminal record. And he took the deal. He became state's witness. He went to the grand jury. He testified to what? I don't exactly know. There were implications of arrests of 2 other people who were friends of the third defendant. The police made it clear that if I didn't take the plea bargain and waive my rights to this trial and considered and pushed against the weight of the state and the government, they said they might arrest my brothers, one or both of them, charge them of accomplices as well. In 1988, when I was 19 years old, when I was facing 240 counts of child molestation, I had 2 co-defendants who at that point had pled guilty, and the idea that the police could arrest anybody at any time, charge them with anything, and that I was going to go into court and tell this jury of Nassau County homemakers that none of this stuff happened was somewhat ridiculous at the time. And I took the plea bargain because it was either that or an assurance of a conviction and the absolute guarantee of a life sentence, literally a 300-year sentence on every single count convicted after trial.
Wait.
Oh yeah, there's more.
There's more.
Oh, there's always more.
The judge in charge of the case, Judge Bachlan, at that time told Jesse's lawyer that if he goes to trial and gets convicted, she will give him the maximum possible sentence, every sentence consecutive, that he will die in prison. She also made it clear that she never had a moment's doubt about Jesse's guilt from the time that he was arrested. And she worked very, very hard to maintain the level of community outrage. For example, this was the first case in Nassau County where television cameras were allowed in the courtroom. Exactly the type of environment where you should be calming things down. She created an environment that was even more overheated. Jesse's attorney was completely unprepared to go to trial, and I think he even acknowledges that at this time. And at that time, people were getting convicted of even crazier stuff than this. I mean, we had a client in New Jersey in 1988, the daycare center case. She was convicted of molesting, I think it was like 37 kindergartners, one of whom claimed that in addition to the molestation, my client turned this kindergartner into a mouse. Yeah, no, that was actual testimony. She turned me into a mouse. She got convicted. She got life in prison. There were no resources at that time for defense lawyers to begin to attack what we now know, 15 years later, is not even junk science. It's just junk. I mean, it took the work of people like Debbie Nathan and others, Dorothy Rabinowitz, over a decade before people finally realized that grabbing a child and telling a child, I know you have been molested, tell me how you were molested, is not a great way to do an interrogation. It took over a decade before people came to realize that if you tell parents, we know your child was molested, the fact that your child is denying that he was molested means that the molestation was really, really serious, because now he's in denial. So the more the alleged victim claims, nothing happened to me, that is the surest positive proof that something terrible happened to him. It took a while for people to realize, no, that probably isn't right. And under those circumstances, I think the decision that Jesse made to plead guilty at the time was the only rational decision that would get him out of prison at some point, as indeed ultimately it did. Well, the answer to that question was, are there any recordings of any of the victims, allegedly, when they were making their complaints? The answer to that question is no. There aren't even any police reports, apparently, of the victims. So that's an easy one.
And there's a reason for that.
Yeah.
The reason for that is because my case wasn't the first of these mass hysteria sex abuse cases. One of the very first was the McMartin trial out in California. And in that case, there were extensive recordings of the social workers talking to the kids and trying to gather information. And it was those videotapes of these interviews that received probably 3 or 4 years worth of pretrial scrutiny. And the word quickly spread across the country to all people involved in child sex abuse law enforcement. Don't videotape, don't take any notes. It's going to hurt you when the case gets to trial. And all that just stopped. The word was, do not videotape, do not take notes. Whatever you do, not until the child starts to tell you nasty stuff, that's when you start writing the stuff down. In my case, it was precipitated by my father's child pornography. When they came to arrest him for the possession of the child pornography, the federal officers realized that my father was running these after-school computer classes for 8, 10-year-old boys, and it raised an alarm for them. They took the names of the students from the house, they gave it to the Nassau County Police, and they said, you got to go do an investigation on this. The guy's a child molester. And they basically, the police, as far as we can ascertain, went to the very first house, knocked on the very first door, and said to the parent, Arnold Friedman's a child molester, and we're pretty certain he molested your child, and this is the kind of stuff we found in his office, and we really would like to talk to your child, preferably alone. Thank you. And it snowballed from there.
And as with so many cases, it wasn't as though the police and the investigators were ill-intended people. I think Jesse has a different view of this, but from my perspective, I mean, most of the time when the police are creating evidence and manufacturing evidence against people, it's not because they woke up and said, gee, what innocent person can we frame today? I know. Oh, let's go with the F in the phone book. It's time for a Friedman. That's not what they do. They go out and they create false evidence against people they totally believe are guilty. And people that are guilty, and as far as they're concerned, are going to get away with it, thanks to people like me, clever defense lawyers, unless the cops do something to make sure that they don't get away with it. And that was very much the dynamic of the police investigation. Fran Galasso, who you all saw on film, to this day, she is completely certain that Jesse Friedman is guilty of every single crime.
My attorney was uncomfortable with the idea that I kept telling him that I was innocent. He decided he could not let me plead guilty unless I confessed to him. That was a big part of his pathology, that he demanded that I admit it to him so that he could stand in court and allow me to perjure myself. But the my father molested me story is just that. It is a story. It really developed as a not so much as a trial strategy, but it was a sympathy strategy in terms of pleading guilty, because once you go into court and say, yeah, I did it, there's really nothing else after that. The hope was that it would be looked upon as extenuating circumstances, and that for opportunities of parole, I would be able to say to the parole board, as well as to the judge at sentencing, and she dismissed the whole thing, but that it was, don't blame me. You can blame me, but blame my father much more. Shift the burden of the anger, shift the community hatred off of me onto my father as much as we could in that circumstance. And really, if I went before the parole board and said anything, what are my options? Yes, it happened the way it happened. Would you please let me go? In which case, they would have absolutely no reason to let me go. I could say it never happened, in which case I would be labeled as in denial and a threat to society, and they would never let me go. Or I could possibly say, well, yeah, it happened, but maybe not exactly the way they say it happened, and there were extenuating circumstances, and please, 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 I'm only a child molester in the framework of, in the computer classes, and since my father is in prison and the computer classes don't exist anymore, I'm not a threat to society, please, please let me go. And that was how that story became and sort of developed and morphed into what it became.
Well, and in fairness, though, I just want to point out, I haven't been able, nobody is claiming authorship of that particular story. I have my own view of the evidence based on the fact that I'm a defense lawyer. And one of the things that lawyers do, and this will come as a shock to you, is they cook up a bunch of bullshit. And this very much sounds like something a lawyer would say and think of: how do I portray my client, who is a victimizer? How do I portray him as a victim? Because we always want our clients, no matter what they've done, to be seen as victims. And in my view, I think that particular lie originated with somebody with a law degree. That's just a theory.
I think it's a magnificent film. I have had various issues at various times with the content of it. At this point, I've totally come to terms with it is what it is. If I had made it, I probably would have made it differently, but I'm kind of glad I didn't make it because somebody much smarter made it than me. In the past, when people have asked me that, I've mentioned that I think the film is fair. And I like to point out that nobody in the film is misquoted. Everyone gets to say their own piece, and the viewers can judge for themselves who they think is absolutely out of their mind and who seems to be making a more rational case for their position. And to that extent, the film does an excellent job. My lawyer, my father's lawyer, did try to request a change of, it's called a change of venue, to move the trial out of Nassau County to a less community hostile jurisdiction. That was denied, of course, by the judge, who wanted desperately to have the trial in her courtroom. Certainly in terms of the jury, the projection was that this was going to be maybe a 3-month trial. And at the time, I remember thinking that the only people who could possibly not get excused from that lengthier trial are going to be Long Island housewives. Anyone with a career and a job and a PhD is not going to sit on a 3-month jury. And in terms of when I put all the charges into so I could sort them in the computer and try to make a demonstration that, as Ron had mentioned, it's just not possible that these crimes happen. It's not that what were the circumstances of the crimes happening, they just could not have happened. I was sitting facing 243 counts. And at 18 years old, with a judge who had said, after trial, if you are convicted, I will sentence you to the maximum sentence, not just for what you're convicted of, but for every single thing you're convicted of. And I'm going to string them all together in a big, long list and see what we added up to. And if the jury came back from deliberations and said not guilty 240 times and guilty 3 times, that's still 25 years in prison.
Well, that's a great question.
Yeah.
I mean, the answer is that the names of and locations of most of the complaining witnesses were never fully disclosed to the defense team back in 1988. Many years later, when Andrew Jarecki started this process, because he brought tremendous resources to bear on the situation, he was able to track down most of...
Many. Some?
50%?
Perhaps,
Okay.
yeah.
Of the students. We're still not sure. And he was able to speak to a number of those. And they were, in fact, depicted in the film. Some of them insisting that this had never happened. Some, including one memorable shot, the young man, now young man, was explaining how this all came back to him. He remembered all of this through the hypnosis that he had been given by the quote-unquote therapists who were working with law enforcement. Of course, at this point, we know that the categorically unreliable evidence are memories that did not exist before hypnosis and now exist afterward. And of course, the trouble with those memories is they are indistinguishable from real memories. But of course, this young man acknowledged that he didn't remember anything until he had been hypnotized. Subsequently, as part of the district attorney's office investigation, although we haven't been given access to their interviews, it's our understanding, I think it's our current understanding that none of the alleged victims.
I think the current, yeah, I think they basically have said that none of the complainants who testified at the grand jury agreed to talk to them for their reinvestigation.
Period.
I believe it's none, yeah.
Children were.
I get along fine with my mom. David gets along better than he did. I can say that my mom is a somewhat nicer person now than she was when I was 15. So there's that going for her in her favor. I am very happily married, 5 years, just in January.
To a woman.
It is. I've checked.
I just, just want to make
I
sure.
checked way before the wedding, but yes.
Yeah, compared to a woman.
Yes.
Right, okay.
Yes, indeed.
Not that that's a judgment, I'm just saying.
I managed in prison rather zen-like, actually. I had found a way to find ways of acceptance, to make the best of the situation, to feel like every day of my life is a day of my life, and whether I'm in prison or I'm not in prison, it's up to me whether I decide to waste it or not waste it. And for the most part, I managed through the prison years emotionally okay. What happened is that when it was finally sort of over when not the first stage in terms of the incarceration, but after 5 years on parole, when I was finally a free person again, except for the fact that the conviction was always there, that's when I started to actually get really angry. And that's when I started having terrible post-traumatic stress disorder symptoms. And I was on the verge of death. That my marriage was falling apart. I could not function any longer. I was just angry. That's all I was. And I found a clinical trial program at the VA in Boston that was doing a couples post-traumatic stress disorder treatment program. And when they spoke to me on the phone, they said, please come up to Boston. When they met me, and I went through their intake questionnaire, and I rated off the charts of symptoms. They said, please come back. And it was almost a year of going back and forth to Boston almost weekly. And my symptoms went from, it was 72 out of, I think, like an 87 was the highest mark, to 22 out of the lowest being 17. And it saved my life, and it saved my marriage, and it saved my sanity, but I get angry all the time still. But I've learned to recognize it and manage it.
The alleged victims, the complainants, as we tend to call them in neutral terms, testified before the grand jury. We have no idea what they said. Even to this day, we don't have the grand jury minutes and have not been permitted to view the grand jury minutes, even for those people who, the complainants that we know, who have appeared on film. We haven't been given access to those materials. So we have no idea what they said, but that was the only time they ever said anything in a formal courtroom setting. Don't know if they were under oath or not. And of course, there was no opportunity to cross-examine them. They were being brought in solely by the district attorney, and that's the total quantity of testimony that exists out there.
Because from a constitutional perspective, don't you have the right to face your accuser?
You have the right to face your accuser if you go to trial. Then you can have all your rights. And after you've exercised all your rights, then the judge has the right to give you basically 250 years to 500 years behind bars as your sort of reward for exercising your rights.
I don't speak to my brother, Seth. As far as I know, he's fine, but that's about it.
I think if we didn't have plea bargains, we would see the prison population, already the highest per capita of any nation on earth, we would see it quadruple or quintuple. I mean, most innocent people who end up getting convicted after trial, after they actually go through the trial process, because most innocent people say, out of their beautiful naivete, I didn't do anything. I didn't do anything. So I'm not going to get convicted, because I'll just go there and explain that I didn't do anything. It's not true. The system is a great system. They'll see that I'm innocent, and they'll free me. Those are the people that account for by far the highest percentage of wrongful convictions. You sometimes get people in serious cases who plead guilty simply because they can't take the risk of going to trial. That tends to be a rarity, except in low-level cases. In low-level cases where somebody's sitting on Rikers Island because they can't make bail, and they're charged with a crime, the maximum which is a year in jail, which is 8 months city time. And they've done 4 months, they've done half their sentence already, and they're told, you know what, you can plead guilty and get out today for time served. Or you can exercise that right to go to trial in about 5 or 6 months, and then you will have already served the maximum sentence. And most people under those circumstances say, you know what, fine, where do I sign? Just get me the hell out of here. But those tend to be for smaller cases, small buy and bust drug cases, those kinds of things. No, none of them have come forward. Yes, we know who they are. And no, we are not allowed to contact them. And more significantly, it is illegal. It is a criminal act for a grand juror to speak about what happened in front of the grand jury. And that obligation of secrecy lasts for the life of the grand juror. So if a grand juror came up to us today, was sitting right here, you got up and the woman next to you said, I was a grand juror. I always knew that was BS. The terrible things happened. But I was outvoted. That grand juror would face immediate criminal penalties. Oftentimes, it's not a big issue, or maybe you were out that day. In this case, though, believe me, all of the grand jurors are well aware, and have been well aware for decades, that if they start to talk about what happened, they will be prosecuted.